Okay, I think we're about ready to get started here. Bob, is your audio there?
Yes, can you hear me all right?
Yes, sir.
Okay, good.
All right, we'll be having other people join us here, so it's time to go ahead and get started. So we want to welcome everybody to our very special educational event today called CYA, Cover Your Assets. This will definitely be a valuable investment of your time. And over the last couple decades, I've been in the financial services arena. I've had the opportunity to learn from many top-level experts on different topics. And once in a while, I'll come across a professional that's a master of their trade and who has the character and integrity to back up that great experience and wisdom. And these are the individuals of integrity that we want to work closely with Clockwork Financial so that we can provide the best strategies and ideas for our clients. Our guest speaker today is one of those professionals. I heard him speak at an educational seminar many years ago, and I remember being very impressed with who he was, his background, how he presented things, his knowledge and expertise on the topic of asset defense. So I actually had him create my own personal asset defense plan, and he's been a pleasure to work with and also for my clients as well. Many clients that have worked with him have had a great experience and have been very impressed with him as well. And we found him to be very thorough, very articulate, very personable and knowledgeable, and just excellent at what he does. So ladies and gentlemen, family and friends, please give your best attention, and our goal is to give our best ideas. It's my great pleasure to introduce to you Mr. Bob Bluhm with the Asset Defense Team.
Well, thank you, Levi. Thank you very much, and thank you for being on the webinar today. And I wanted to just give you a quick background about myself. I've been a lawyer since 1985, over 30 years now, and you do a lot of things in 30 years. I started as a trial lawyer, a litigator, in a large international law firm with offices all over the globe. And then after some time, went to an international oil company, which is now part of British Petroleum. And then because you do a lot of things in 30 years, represented for a period of years the world's largest airline. And as I mentioned, all of that was done as a trial attorney. In other words, I sued people for a living. But then I did that for about the first 15 years of my career. And then since then, I have taken everything I learned about suing people and now use it to protect people from lawyers like I used to be. And so now I am considered to be an asset protection attorney. That is my field of specialty, and I work extensively with real estate investors and business owners. So what I want to frame what we're going to talk about today is this. All of us have a way of making money, whether it's investing in real estate, owning a business, having other types of investments. And making money is critically important, as we all know. But the problem is most people overemphasize it. They think that's all there is to it. All I have to do is make more money and all my problems are going to be over. Well, I think you're all smarter than that, because you know that offense is a very important part of the game, but offense is only half the game. The other half of the game is defense. And that is what I'm going to talk about today. Defense consists of paying the minimum lawful amount of taxes and using techniques to lower taxes and to make sure that your assets are protected from lawsuits, levies, liens, and seizures. And then finally, that our estate plan is in place and we lose nothing through the probate and estate tax process, inheritance tax process. So that is my job today, is to talk to you about defense. So getting started, when many people become business owners for the first time, they feel as if they become a target for higher taxes from the government and a higher risk of lawsuits. So the goal is, yes, you want to have your own business because you can make a tremendous amount of money and become financially independent that way, but we want to lower our taxes and have lawsuit protection, and that is what defense is all about. So to start with the first of these topics, and that's lowering our taxes, we want to consider what are the three requirements that the federal government has set out in order for us to pay the bare legal minimum in income taxes. And the first is to simply own a business. The reason is because business owners get the vast majority of tax deductions in the tax code, while non-business owners, who would be considered W-2 employees working for somebody else's company, by comparison, get very, very few. So if you own real estate, that is clearly a business. Own rental property, clearly a business. Own any other type of a business, that is a business, and you have satisfied the first requirement, because you have now opened yourself to a panoply of deductions that employees are not entitled to. Now, once we have a business, the question is always, what is the proper business structure that will allow me to maximize my deductions and at the same time give me liability protection? There are many, many ways you could run a business in our country today, but only one of these will give you all the tax deductions, all the goodies in the law, and it is called a limited liability company, an LLC. People know it by its acronym. And that is true if the LLC is taxed correctly. And if you're not sure what I mean by that, I will be explaining that in just a little bit. All right, now one thing I do want to mention is one of those possibilities is to be a sole proprietor, and I want to emphasize you never, ever do business as a sole proprietor. The reason is, if you're a sole proprietor, you and the business are one. When they sue the business, they are suing you. There's no separation between you and the business. And when they sue the business, in other words, your personal assets are completely at risk. The goal of using a limited liability company or any other type of business entity is to separate your business activities from your personal activities, and thereby, if the business is sued, your personal assets are not at risk if it's been done properly. So we never want to do business as a sole proprietor. All right, now a properly structured limited liability company can lower your taxes, it can protect you from lawsuits, and it can protect you from IRS audits. Wonderful benefits. But the real problem is most LLCs don't lower your taxes. They do not protect from lawsuits, and they do not protect you from IRS audits. And the reason, quite simply, is because they don't lower your taxes because they are not taxed correctly, and there are no resolutions authorizing the various deductions. They don't protect you from lawsuits because typically people use cookie cutter documents, sometimes even worse, off the internet, that they have no idea what they really say. And then there are no key words in those documents that give you the liability protections. It's not an automatic thing. And then most LLCs do not protect from IRS audits because, once again, the limited liability company documents do not authorize the deductions that the IRS is looking for in those authorizations. So the key is we do want to own a business, but we've got to use the right business structure, and that would be a limited liability company with the correct tax method. Now, having said limited liability company so firmly, I do want to leave the door open for people because there are times when it is appropriate to have a corporation. Now, I'm going to talk about briefly the difference between a corporation and a limited liability company, but with a corporation within the tax realm, we can have it taxed two different ways. One is an S corporation, and the other is as a C corporation. Now, the S corporation is generally known as a flow-through entity, which means that it itself does not pay taxes. The entity does not pay taxes. The profits and losses flow through to you, and it's ideal to use an S corporation when we have a startup business, which may produce a loss. And the reason is you can take the entire loss and use it to offset other income you may have from salaries or investments. And so even though you may not have made a dime in your business, you have lowered your taxes when you have an S corporation and a loss. Now, obviously, no one wants to operate at a loss for very long. And so the goal is we want to be making a profit. And when we're making a substantial profit, then we want to be using what we would call a C corporation, because the C corporation has by far the most numerous and generous tax deductions available to any type of corporation. And so by maximizing our deductions, we lower our taxable income and thereby lower our income taxes. In other words, we shelter more income from taxes. Now, the big difference between an S and a C corporation is S corporations give you minimal fringe benefits, which are the same thing as deductions, and C corporations give you generous fringe benefits. If any of you have ever worked for a large corporation, they have very generous fringe benefits. One of those is medical deductions. And with your own C corporation, you can deduct 100% of health insurance premiums, deductibles, co-payments, prescription drug costs, alternative remedies such as massage or chiropractic or acupuncture or Chinese medicine or whatever you want to call it, vision expenses, dental expenses, all are deductible through a C corporation. Not so with an S corporation. So the C corporation can be used when we're making a substantial profit. Now, the limited liability company, on the other hand, differs from an S or a C corporation in the sense that it can be taxed 4 different ways. A limited liability company can be taxed as an S corporation, a C corporation, a sole proprietorship, or as a partnership. Any one of those 4 methods you may choose. Now, in other words, if you have a limited liability company which is taxed as an S corporation, it's the same as if you have an S corporation from a tax standpoint. If you have an LLC taxed as a C corporation, it's just the same as having a traditional C corporation from a tax standpoint. All right. Now, the other aspect of a limited liability company is it gives you actually enhanced lawsuit protection. Now, we could, if we had more time, go into lots of detail with regard to each one of these forms of taxation, but we're not going to be able to do that at the moment. We'll be happy to explore that as to what type of taxation method would fit your business best, because there is no standard answer. It depends upon the individual facts and circumstances of your business. All right, now, one word of caution with regard to limited liability companies, and this has to do with lawsuit protection. There is a very common type of limited liability company called a single member LLC, which means you are the only member of the LLC, the only person in it. That means that it is considered a single member LLC as opposed to a multi-member LLC. And the problem with that is that the single member LLC in many, many states does not give you liability protection. In other words, they can pierce the veil of the limited liability company and reach your personal assets. So if it's a single member LLC, as a result, we want to use multi-member LLCs, and then the question becomes, should it be a manager-managed LLC versus a member-managed LLC? And that, once again, depends. But it does have significant tax consequences. One of those will give you very good tax benefits. So to briefly summarize, to lower our taxes, the federal government requires that we satisfy 3 requirements. The first is we want to own a business because that's where the deductions are. Second of all, we want to use the correct business structure, and as a general rule, because of the greater flexibility in taxation, the limited liability company will generally be the correct tax, with the correct tax method, will be generally the most appropriate legal structure. And then the third requirement is we want to use certain keywords in our corporation documents. Generally speaking, we're talking about keywords in the limited liability company operating agreement that will authorize certain tax deductions and provide certain liability protections, very important. And if it's a corporation, we're talking about in the corporation minutes and various resolutions. So keywords are critical. In other words, what we've talked about here is a forward-thinking plan for your money. In other words, we're anticipating we're going to make a certain amount of money. How are we going to reduce the taxes on that money? And that is done through certain structures with certain tax methods. In other words, you must have a plan for your money, because if you don't have a plan for your money, you know who does have a plan for your money, and you're not going to like that plan. Now, to shift gears briefly, we want to talk about lawsuit protection. And in talking about lawsuit protection, there are so many ways we can be sued. One way, and I'm going to go through these very, very briefly. One way is divorce. Obviously, that's a lawsuit that many people don't think of. We can, if we have a business with one employee, we can be sued for wrongful discharge, various discrimination types of claims, or for whatever the employee does. The employer is liable for the employee's actions. We can be sued for guest accidents in our home, slips and falls, etc., injuries, and even though we have insurance, you never know if it's an adequate amount of insurance, because you never know what the injury is going to be. A fourth way we're sued is because of joint ownership pitfalls. The general instruction from us is never own assets jointly. The reason is, the rule being, if you own assets jointly and your joint owner is sued, you can lose everything you own jointly with them, even though you did nothing wrong yourself. So the rule for our clients is, do not own assets in joint ownership. There are much safer ways for two or more people to own an asset. We do not want to use general partnerships, the reason being that a general partner has full liability to bind the partnership. And if you have another partner, they don't have to consult with you, and they can bind the partnership. In other words, you can lose everything you own because of something your partner has done. So another way we can be sued is if you are an officer or director of your company. Officers and directors are personally liable for what the corporation does wrong. If you are not officially an officer of the company, but you act as if you're a company, you look like you're a company officer, then it's the same as if you are an officer, because courts look at function over form. Another very big way we can be sued is simply because we are the owner of an asset, which is quite dangerous. In other words, the owner of the asset is liable for what the harm the asset causes. A typical example is if you're the parent of a teenager who is just learning to drive, they cannot own their own vehicle until they reach a certain age. If they get into an accident, mom and dad are sued because mom and dad own the car. Be careful what assets you have your name on the title of. Products liability, if you're selling a product, the famous product liability case is the McDonald's coffee case. The hot coffee that spilled, and McDonald's was sued for millions of dollars. Finally, almost finally, insurance was something we always want to have, but once again, insurance companies are loath to satisfy claims and provide coverage if they do. If there's a way they can get out of it, they do, and leave you high and dry, which is why you need your own backup plan for liability protection. And then finally, if you're in business, you're signing contracts, if you're a real estate investor, you're signing leases, etc., management agreements. If you're a business owner, you're signing purchase orders, etc. Every one of those is a contract, and you open yourself to a breach of contract claim if the other side thinks you didn't satisfy the contract. So all of these things present liability to us because of a legal doctrine called vicarious liability, which basically means you can be sued for what someone else does wrong. In other words, the example again, you can be sued for what your kid does wrong if he's driving your car, and you can be sued for what your employee does wrong if they are in the scope of their employment. Vicarious liability basically means these are things you don't control. And we like to think we're in control. The reality is we're really not. So the way we protect ourselves is, of course, we mind our P's and Q's. We try to do what's right, but there is that very large realm of things we do not control. And because of that, we want to have our assets protected. And we do that with what is called a lawsuit protection entity. I'll give you more about that in just a moment. But before we go there, I want to briefly mention estate planning principles. When we pass away, we will go through what is called probate. It is a judicially supervised settling of your estate. Once the estate is settled, then the assets can be distributed to the intended beneficiaries. The problem is probate requires lawyers. It's a court procedure. It costs money. It's lengthy. Anything to do with the court is time consuming, and it destroys your privacy because you created a public record in court. So anybody can see who got what, how much, and what their address is. And if this is not what you wanted to do to the people you've loved and protected all of your life, then you do not want to go through probate. And one of the biggest things people don't understand is wills automatically take you to probate. Having a will means you're going to go through probate. So the way we avoid this probate process is to use a wonderful tool called a living trust, which protects against probate. Real estate investors, I want to mention, if you have real estate in more than one state or assets in more than one state, you will go through probate in every one of those states unless you have a living trust, which now eliminates probate and makes sure your loved ones get the assets within hours after you pass. And it can literally be that efficient. Now, one thing to make sure you understand is the living trust is a wonderful tool for protecting it against probate, but it does nothing to protect your assets from a lawsuit. Living trusts do not protect assets from a lawsuit. The tragedy we see is that people go to a lawyer, they say, we need to get our affairs in order. The lawyer says, well, let's set up a living trust, and they do, and then they fund it with their home and their savings and their stocks and mutual funds and real estate and rental properties, and everything we own goes into that living trust. And then we think we're set up to avoid probate, which we are, but we're also set up to go broke. Because if just one lawsuit strikes set up this way, that lawsuit now has a ripple effect, a domino effect against every other asset in that living trust. It takes them down in flames. We lose it all. An entire lifetime of work is lost because we fail to understand that the living trust was never designed to protect our assets from probate. The tool that does protect against probate is called a lawsuit protection entity. Now, this is a generic term, and there are two very specific legal structures that qualify as a lawsuit protection entity. One is called a family limited partnership, and the other is called a limited liability company, which again, we know as an LLC. All right? Now, one thing I want to mention is that many LLCs have become very, very common. They're quite easy to set up because all we have to do is, there are these services like LegalZoom, which we call LegalDoom. And then there are, you can simply go to the Secretary of State website and fill out the articles, and you've got a limited liability company. But not all LLCs are the same. You know, we can say, yes, I have an LLC. Well, what does that tell you? Virtually nothing, because you could say, by comparison, I have a house or I have a house. It doesn't speak to the quality of the house. It doesn't say anything about the size of the house, the age of the house, the condition of the house. Another thing, we could say I have a car or I have a car. We could say I have a bank account or I have a bank account. And as you can see, these words simply really mean nothing. So the question is, what does your LLC look like? If all we did was we went to the Secretary of State's website, we filled out the articles online, and here we have the articles, which are often 1 or 2, maybe even 3 pages at most. That's your LLC. In reality, a limited liability company should be fully, that is the equivalent, I should say, of if you're building a house, you've created the foundation for the house. But I don't think you'd want to live on the slab that is shown here. You want a real house. So that's what you want to live in, all right? So instead of having a 1-page limited liability company, what you want to have is a fully formed limited liability company with an operating agreement, with and an operating agreement, I should say, that is customized to you and your particular business. not some cookie cutter operating agreement. And then beyond that, minutes, resolutions, and many, many other documents that provide liability protection and tax reduction. All right. So the question is this your LLC or is this your LLC? And once again, simply saying I have an LLC really tells you virtually nothing. All right. So let's talk about why lawsuit protection entities protect so well. And it's because of something called a charging order, which we'll get to in a minute. But in order to protect, the principle is this: before the lawsuit strikes, we must get our assets into the family limited partnership or the limited liability company. Once the lawsuit has arrived, it's too late. It would be considered a fraudulent conveyance to try to protect our assets after the fact. So the reality is, if we want to protect our assets, it's got to be done in the clear light of day when there's no threat of a lawsuit. You're doing it for planning purposes and not to defraud some potential creditor. All right? So the time to do this is not later, it's now. All right? So once we have our limited partnership set up, once we have the assets protected by the limited partnership, now here is the nuts and bolts of why this protects you so well. It is because when someone sues you, they sue you. You are a member of a limited liability company or you are a limited partner in the limited partnership. Now, if they win the lawsuit, and let's say they win the lawsuit for $2 million against you, they get a judgment for $2 million. Now they will get what is called a charging order. The charging order is the remedy in every one of the 50 states that a judgment creditor gets. And judgment creditor means the person who won the lawsuit against you. This is what they get for winning. It's not a levy or lien or a seizure. It is a charging order, and it gives them 3 migraine headaches. Headache number 1 is the right to seize a certain percentage of your assets in the limited partnership. The exact percentage they get to seize every time by law is 0. They cannot seize, attach, or levy upon a single asset in your limited partnership, and that is the law of the land if you use this tool. No assets are seizable. Now, they cannot take your assets, but the law says we're going to let them take the net income of the partnership that you distribute. Now, I want you to hear that phrase again. They can take the net income of the limited partnership that you distribute. I'm going to read to you from the limited partnership that my partners and I have spent many years perfecting. This has been called the most protective clause ever placed in a limited partnership. Now listen very carefully and then think to yourself, how much of your hard-earned income are you ever going to be forced to give to someone who sues you? Here it goes. It says, the general partner, which is, by the way, you, the general partner of the limited partnership, or I can say manager of the limited liability company, shall distribute the That means the winner of the lawsuit gets 0 income because that the winner of the lawsuit actually was entitled to receive $2 million from you, but couldn't figure out how to get it. We don't care. Even though the winner of the lawsuit got nothing from you, the winner of the lawsuit still must pay income taxes on the $2 million that you never gave them. Now, think about this. Who in their right minds is ever going to want to sue you or me with our assets in our family limited partnership or protected by a limited liability company? And the prize for winning is they're going to get none of your assets. They're going to get none of your income, but instead of getting your assets or income, they're going to get a tax bill on income you never gave them. Folks, that is the beauty of these lawsuit protection entities. It is the charging order which protects you so well. Now, if you want this result, I want to emphasize that it's not automatic. It must be done through certain key words in these documents. In other words, it's got to be properly drafted. And the only way you're going to get the benefit and protection of the charging order is with properly drafted family limited partnership or limited liability company document that specifically define, I should say, the distribution terms. In other words, are we talking about a pro rata distribution or a non-pro rata distribution? Are we talking about a mandatory distribution or a discretionary distribution? That's got to be there. The family limited partnership or the limited liability company can protect assets from a lawsuit if it is structured properly, and that includes having certain key words. Now, the key is this. If you're being sued and all of your assets are on the line, maybe your retirement funds are on the line, the question is, what kind of limited liability company do you want protecting you? A one-page limited liability company where you simply file the articles, or a fully formed limited liability company that authorizes loads and loads of protections already built into that LLC? Same thing is true with a family limited partnership. Once again, you could have a one-page certificate of limited partnership, nothing else, if you did it yourself on the website, but a fully formed limited partnership is going to look like we have on the right, with all kinds of protections built in. If it's down to the wire, you want, and your assets are on the line, you want to make sure you are protected with the right documents. One woman said this: my husband was involved in an auto accident that killed one man and injured another. The second man sustained injuries that cost over $1 million in medical bills. I was sued for everything I had. I hadn't done anything wrong except for owning a Lincoln Town car in joint ownership. I was being sued for millions, and my entire estate was at stake. After the plaintiff's attorney received copies of my limited partnerships, I didn't have to pay them anything. Your structuring saved me over $3 million plus my entire real estate career. I will always be grateful. So the question is this: if we have assets, which we all have and hope to have, the question is, how do we want to own those assets? Because that will determine whether they're protected or not. If we own everything we have in, say, joint ownership or our names, or even in a living trust, you have no liability protection at all. Because if you want to own everything you have in joint ownership, that's legal. There's nothing wrong with that, except that if a lawsuit strikes, you can lose everything you have because you have all of your eggs in one basket. If you want to own everything in your name and a lawsuit strikes, you can lose it all. If you have everything you have in a living trust and a lawsuit strikes, it is gone. So instead, if we want to protect our assets, we put them into a family limited partnership. And now if someone sues us, what do they get? They get no assets, no income, and they get to pay income taxes on income you never gave them. Folks, this means you've got defense covered. You can turn your attention back to offense and win this game. That's what it's all about. Now, quick review. Let's think this through. If you want to protect your assets from a lawsuit, the tool we want to use is called a family limited partnership or a properly structured limited liability company. If we want to eliminate probate, the tool we want to set up is a living trust, not a will, a living trust. If we want to pay the least amount in income taxes, The way we do that is with a limited liability company with the correct tax election, all right? Or a properly structured S or C corporation if that's appropriate for your business. All right, so these are your major defensive tools. Now, if we had a legal structure that looked something like this, ask yourself, would this legal structure protect you better than just having all of your assets in all of your eggs in one basket? I think the answer is clearly yes. If we had a legal structure that looked like this, would this legal structure help us pay lower income tax, lower estate tax, and zero probate expense? And the answer again is yes. So this is a rough outline of a legal structure, simply meaning that these are the legal tools that we would use. Now, these can be arranged in many, just like Lego blocks can be used to form any type of image or structure. The same thing is true with these types of tools. We can have multiple limited partnerships, multiple limited liability companies, depending upon the particular mix of assets that you have. Well, the one thing I want to tell you is this. One woman said, my husband and I have two of your lawsuit protection entities. We took them to our attorney, and he said they were bulletproof. As you sit here right now, you can ask yourself, am I bulletproof? And if the answer is maybe not, the good news is with a little bit of planning, you certainly can be bulletproof. Folks, I represent Asset Defense Team, and what we're going to offer today is, for you being a Clockwork Financial client, is a 30-minute complimentary asset protection consultation, in which we are more than happy to have a phone conference with you at no cost, and we can explore the types of assets that you have and the types of solutions that may be appropriate for you. So in closing, I want to mention that, of course, Clockwork Financial has excellent financial products for offense. What we've talked about here today is defense. And you put the two together, and it really results in not only more income, greater financial security, ultimately it results in peace of mind. And you've got to ask yourself, what is that worth? Because it's what we strive for every single day. Levi, I'd like to turn it back over to you, and if anyone has any questions, I'm more than happy to answer them.
Very good, Mr. Bluhm. Thank you so much. That was very, very valuable information. Hopefully that gets everybody thinking about what they have, what they're doing, what's potentially not working to the level that it could. And I know you are up there with the best of the best at what you do, and we appreciate you being so good to us and our clients. I also want to throw out there that Mr. Bluhm has offered a discount for Clockwork Financial clients versus his traditional fees to get some of these things set up if you so desire to do that. So make sure you mention that. And also, if you have any questions, please type those in the chat window now. If there are any, then we can see if that's an appropriate question for Mr. Bluhm now, or if that would fall under a more private, confidential type question that's only specific to your situation, maybe. One question is, if you have a trust and a will, does that make you go through probate, or does that still avoid probate if you have a will in addition to the trust?
Well, a will and a trust often work together if the will is called a pour-over will. And the idea of the pour-over will is that it's sort of a cleanup mechanism, the notion being that if you didn't get everything into the trust, because let me step back a moment. In order to avoid probate with a living trust, you have to have every one of your assets titled or owned by the living trust. Any assets that remain in your name at your death will go through probate. Now, the purpose of the pour-over will is to do just that. Have that image of pouring over any assets not in the trust into the trust at your death to preferably try to hopefully avoid probate. It's not a guarantee that it will, but in many states, the pour-over will have that effect. So, let me ask you, or say this, if the will was created first and then the trust came later intending to supersede the will should be revoked, meaning that it's now the operative document is now the living trust and not the will. Otherwise, it could cause confusion. So you may want to go back to. I'm sorry.
Is that mainly a function of the date of the will? So, like, if the will is dated before the trust, then that would have a different intention versus a pour-over will that's dated at the time of the trust initiation or after.
That's correct, and that's typically what we find. A will that was created many years earlier, and then a trust that was created later, that will probably should be revoked. What I'd recommend, rather than just simply revoking it, go back to whoever created the will or the trust, make sure that they review that and that everything is in proper order.
Okay. Looks like a couple other questions here. Is it better to have a trust in the tax ID number of the grantors of the trust, or to give it a separate EIN number from the IRS?
Well, typically it's adequate to use not the EIN number, but the Social Security number of the grantors, on the assumption that the grantors are mom and dad, and they're individuals, and it's a family trust that holds generally personal assets. Now, if it's the type of trust that is going to hold assets that are generating significant income, such as possibly even a business, then that trust should get its own EIN number.
Gotcha. Okay. And looks like maybe the last question, is there a statute of limitations on distributing the net income from the LLC? Like you talked about, the avoiding a charging order, and the net income is only distributed if the manager decides to, and if they decide not to, does that just, what if they need the income but they don't want to have to pay it out to a frivolous lawsuit or something?
Well, a distribution is a defined term, and it is very specifically defined as a distribution. In other words, a paying, I'll use different words, a paying of each one of the limited partners or partners in the partnership according to their percentage interest. Now, there are many ways that you could pay yourself that are not considered a distribution. So in other words, there can be a service agreement in which you provide services to the limited partnership or limited liability company, which would be paid as perhaps a vendor, like a vendor to a business is paid. That's not a distribution. There could be a management agreement, once again, a type of services agreement, or there could be debt repayments. For instance, if you loaned money to the limited partnership and it's paying you back. These are all obligations of the limited partnership that are not What if you didn't have any of those things in place? Well, realize that the judgment creditor is going to have to pay income taxes on income that they did not receive that year. Now, you've got to ask yourself, how long do you think a judgment creditor is going to keep a judgment in place as opposed to voluntarily dismissing that judgment if they've got to pay income taxes every single year with no end in sight, realizing that it's just a question of who can hold out longer without making distributions. So it's a very good vehicle for being able to settle a case on much more favorable terms than you otherwise would, for having the judgment creditor voluntarily abandon or vacate the judgment. And so I think you can see it simply gives you much greater leverage and puts you in a much stronger position with the very real likelihood that you'll be receiving loads of income without ever making a distribution, and the judgment creditor is ending up suffering significantly, having to pay taxes on income they never receive.
Right. Very good. Well, the longer I'm in this business, the more I see problems and things done inaccurately that cost a lot of money. So this is definitely a wise investment into protecting what we have, what we've built, what we want to leave behind for our family and loved ones. So very valuable information. Looks like all the questions we have right now. Thank you so much, Mr. Bluhm, again for sharing your wisdom with us, and hopefully your phone is ringing off the hook with people wanting to take advantage of a 30-minute complimentary consultation to see if there's any other areas that we can make further progress on. So you guys can go to assetdefenseteam.com and see how to contact Mr. Bluhm. You can reach out to him via email, info@assetdefenseteam.com. His phone number is also on the screen and on the website. So excellent defensive game plan that he can help put together. On the offensive side, of course, we're always here to help grow and protect and make sure that your wealth is going in the right direction for you, your business, and your family. So you guys have a great day. Thanks for being on the call, and we'll talk to you later. Bye-bye.